Let's talk a little bit about the attorney-client privilege. Communications between an attorney and a client are privileged, meaning that they can't be disclosed by the attorney. The reason for the attorney-client privilege is that the attorney-client relationship needs to be one where information is traded very freely without the client worrying that anything that they say could be used against them in the future. Attorneys in California are required to put forward the privilege whenever asked to disclose a privileged communication between a client. That means attorneys have a duty to claim the privilege. For purposes of the privilege, an attorney is anyone who is licensed to practice law in the state of California, or who the client reasonably believes is licensed to practice law anywhere. A client is anyone who confers with an attorney either to obtain legal services or to consider retaining the attorney. So a client may not have actually retained the attorney for the privilege to apply. Communications that occur before the client retains the attorney are also privileged. The attorney-client privilege continues to protect communications between the attorney and the client even after the attorney-client relationship comes to an end. But it only protects communications disclosed in confidence. That means that if, as a client, you're in the office with an attorney making communications, if there's anybody else in the room, the privilege may not apply. You can waive or eliminate the privilege by disclosing significant parts of the privileged communications to third parties, or by simply waiving the privilege in writing. And finally, there are a couple exceptions to the attorney-client privilege. The first is the crime-fraud exception. If you as the client are seeking to engage an attorney to help you carry out a crime or a fraud, or to get advice about doing so, the attorney-client privilege does not apply to you. And finally, a lawyer who reasonably believes that disclosure of the communication is necessary to prevent death or substantial bodily harm can do so without getting in trouble for disclosing confidential communications. So that's a little bit about the attorney-client privilege. It comes up in estate planning all the time because when I'm talking with clients, they're telling me about their personal lives. What are your assets? What are the people who are important to you? And I take the privilege very seriously.